Are you an applicant attorney or an injured worker, and in the process of adjudicating a California workers' compensation claim, you have been seen or your client has been seen by a panel qualified medical examiner and it's an adverse medical opinion and you're looking for a way to get a replacement doctor or a new doctor to adjudicate this? There's a few cases that recently came down. The case is called Cowell versus County of Los Angeles, really reiterating the holding in Navarro, but these cases can help. Hi, my name is Michael Burgess. I'm a legal certified specialist in California workers' compensation, and I'm a trial attorney. I want to talk about the case of Cowell versus County of Los Angeles. And really the holding on this is not revolutionary because it's really upholding the same decision in Navarro, which is an en banc decision I've previously discussed in my videos. It does clarify a very important issue here. And let me give you the backdrop here. What the holding in Navarro is and how important it is to an injured worker is, there's a dispute that has arisen in the case, and we've obtained a neutral panel qualified medical examiner evaluation, and it's an adverse report. It's a BS conservative doctor who's screwing your client, okay, or the injured worker, right? And what Navarro was if you file a subsequent claim or date of injury, or even dates of injury previously, the applicant attorney or the injured worker is saying, hey, I don't want to go back to that panel qualified medical examiner who washed me out. He was only the panel qualified medical examiner on that claim and that date of injury. And there is a huge fight between applicant's bar and defense bar, defense saying, nope, once you have a panel qualified medical examiner, no matter what, you have to go back to this doctor. Of course they wanted that because they wanted this doctor to continue writing conservative washout report for injured workers. And of course the injured worker or their attorneys was saying, no, this isn't fair. This is a new claim. I'm not entitled to go back to that doctor. Well, Navarro came down and essentially said, if it's a new claim, you are not obligated to go back to that panel qualified medical examiner. However, there's some ambiguity about what about existing cases, right? Or cases that were wrapped up prior to that date of injury. So then there was a dispute. Well, some defense would argue, well, prior dates of injury, under Navarro, you're not entitled to a new panel because we already have a panel to address those. And their contention was only subsequent injuries was an injured worker entitled to a replacement or a new panel qualified medical examiner. Well, this case essentially comes down and makes that determination dispositive because it indicates that it's not the date of injury that's dispositive, it's the date of the claim. So even if it's an older date, if the claim form is filed timely, subsequent to that PQME evaluation, under Navarro, the injured worker is entitled to a new PQME to adjudicate that. So what does that mean? Well, if you're an injured worker or an injured worker's attorney, that means you can look at your file. If you get an adverse PQME washing your client out and you want another bite at that apple, hopefully to find a good neutral doctor, right? Medical evidence that you can rely on at trial to get your client or the injured worker benefits, you need to work up the medical evidence. So what I would do is I would look through the claim and look to see if there are any dates of injury that haven't been filed. And if that's the case, file those dates of injury, get a new panel qualified medical examiner. Also, what's really interesting in this case is there was apparently a lot of overlap because it looks like the original claim was a cumulative trauma up to about 2018, and then it looks like the subsequent claim was virtually an overlapping duplicative cumulative trauma pled to a later date. And the WCJ at the trial level, the judge at the trial level, indicated that the injured worker was not entitled to a replacement doctor, and basically these injuries were duplicative and it should go back to the original PQME. And the WCAB actually reversed the judge and said, no, first off, they're technically, the new one is a subsequently filed claim, and ultimately the board is very liberal on dates of injury, and you can even amend the date of injury the day of trial in conformity with the medicals, and the holding is clear. If it is a subsequently filed claim, even if that claim is for a date of injury prior to the PQME's evaluation, the injured worker is entitled to a new panel qualified medical examiner. So if you're an applicant attorney or an injured worker this is a very good case to help use. And when you get a replacement doctor, it does drive up the cost for the litigations and the defense. And very often it's a tool that you can use to get an adequate settlement. Or if you can't use the leverage to get an adequate settlement, get the medical evidence you need to promptly adjudicate it down at trial. If you have any questions or concerns, honestly, I'm here to help everybody, including other applicant attorneys. If you have any questions, I have the answers. Feel free to give us a call. We're standing by. Did you like this video? You may find these videos to be helpful as well. Please click the links below.